Hi, I'm Philip Hundl. I'd like to, as part of this video series that I've been doing from time to time, I'd like to talk about if you're a potential landowner, potential purchaser of land, being aware of pipeline easements or other easements, high voltage transmission line easements, road easements, access easements, but whatever type of easement encumbers that property, to be aware of it prior to purchasing that property. So just a real quick summary of purchasing property, at least in Texas. There's kind of a standard procedure typically. Doesn't always happen this way. There can be obviously cash deals without title companies involved, without title insurance involved. But for the most part, when someone's purchasing some land in Texas, they are wanting to, or they will want to get a title policy ensuring that whoever they're buying the land from is in fact the record title owner, in fact the owner of the property, the fee simple owner. And so let's walk through that. Normally there's an earnest money contract signed by both parties. That earnest money contract's taken to the title company, deposited at the title company along with the earnest money, and that then quote unquote opens title. These are words that normally you'll hear from title companies, the escrow agents that work there, the closing agents that work there. They'll open title. That opening title creates a file, and that file has a GF number, just a way for the title company to track it. And then the title examination begins by the underwriters that will possibly be issuing the title insurance. Title examination goes back in time and looks at the chain of title and how the property passed from one owner to the other, to determine who is the current owner of the property, and hopefully the current owner of the property is the one that signed the earnest money contract as seller. So if it's not, then right immediately you've got some issues, or you got some questions to answer more than anything. But moving on to title examination, there then gets created a title commitment, and then the title commitment does what it says. It's a commitment that says if these things are done, then a title insurance policy will be issued. So it's a title commitment. And in the title commitment, there's certain schedules or pages to it. And there's a Schedule A, and I'm actually going to refer to one right now so that I don't misstate anything. But the Schedule A talks about how much the policy will be that's going to be issued, who the record title owner is, and the legal description of the property. And that's another thing, too. You need to make sure that the legal description of the property, if you're buying 10 acres, that it's 10 acres and not 5 acres, because then the title policy may only apply to the 5 acres and not the whole property you're buying. Then we go to the Schedule B, and this is the one I really want to focus on. The Schedule B it talks about the different encumbrances on the property. And this is where you're going to pick up any oil and gas leases, easements, utility easements, power line easements, road easements, you name it. It's going to be on there. I mentioned, and if there's deed restrictions, HOA restrictions, it will be on there as well. A lot of times it has these catch-all terms as well of any and all leases recorded or unrecorded, or tenants in possession. So things like that you'll see. But like I said, I want to focus on, it will have recording information for these easements that affect the property. And so you need to really look at those. And the title company is going to have these documents available either electronically in a hard copy for you, so you can go and you, the buyer, along with, I suggest, an attorney that is familiar with real estate, to review these easement agreements to tell you what exactly it means. Hey, there's a 30-foot wide permanent pipeline easement, or there's a 60-foot wide high voltage transmission line. Obviously, you can see the high voltage transmission line if you go out to the property and look at it, but the pipeline easements sometimes not as identifiable. There should be pipeline markers at or near the boundary line of the property or where it crosses a road, but very possibly not. Or in these cases of, and I mentioned in another video, Atmos Energy, there are these very old pipeline easements that actually may be inactive, but because of the way they were written, they're still permanent, they still exist, and all of a sudden new pipeline company owns them and can potentially reactivate them or use them again and install a new pipeline. So what's important for you as a landowner, and I just had this not too long ago, a landowner purchased a property and it was burdened by a pipeline easement. Some of the terms of the pipeline easement required basically Nothing could be done in the easement area. The easement area was about 60 feet wide, I think, somewhere around there. And the landowner wanted to just build a driveway across it. And unfortunately, according to the easement terms that were agreed to by the prior owner of the property, a road or driveway over that easement area needed to be approved by the pipeline company. Well, that sounds easy or it sounds simple, but the pipeline company required a lot of different things from the landowner, engineer drawings, diagrams, you name it. So it was pretty burdensome on the landowner to get all that information to the pipeline company. And then the pipeline company really wasn't in much of a hurry, but they weren't very fast in reviewing and getting approval. All the while, the landowner was on a tight schedule to get this road installed, road built, and start his construction on his home. So that created an unforeseen delay that, potentially caused some problems for the landowner. So be aware of those encumbrances. And like I said, on a title commitment will be listed on Schedule B. Now, just for the sake of completion, Schedule C of this title commitment talks about really the things that need to be done by the parties, normally by the buyer or even the seller, to clear up any, we always call it anything, any defects of title that need to be cured. So the Schedule C is the things that, hey, these are things that need to be done. And if once these are done, then the real estate closing can happen and good title can be transferred. That doesn't mean without encumbrances, it's going to be subject to those encumbrances on Schedule B, but at least the transaction can be done. So hopefully that's helpful. I once again just want to reiterate, if you own land or will be buying land, please pay attention to the encumbrances on the property, the things that burden the property, like various easements. Okay? So with that, good luck. Thanks.